Welcome. I'm Douglas Jackson, and this is Introduction to Veterans Disability Law. This is a preliminary course that will give you an introduction and follows some of the writing that we prepared. This particular chapter is Chapter 1, which is just an overview of veterans' disability. This program will be updated and enhanced as we continue to progress. But initially, it will provide you some background and hopefully is an educational experience. What is veterans' disability? We all know about war, and we know that war is a dangerous proposition. It impacts all who are part of the process. It kills people. It injures people. No one comes out of it the same, whether it's just mentally or physically. All suffer some damage from it. Those brave people who have sacrificed that, they are entitled to something. Our United States government attempts to compensate its members in the military. It has a program called Service-Connected Compensation. This works a little bit like workers' compensation benefits. Essentially, those who get hurt during their military service, they get some benefits, whether monetary or a promise to give medical treatment to compensate for their losses. Now, some argue that the government does not make good on these promises, and, well, to be truthful, we would not be employed if they did not always make good on these promises. Unfortunately, sometimes it is quite the battle. When the government does fail to make good on these promises, that's when veterans' disabilities lawyers step into the picture. Too often, veterans' claims for disabilities are wrongly denied or incorrectly underrated. The process to fight this takes significant time, but veterans' disability lawyers can help disabled veterans to secure the proper compensation. These lawyers advocate to ensure that the government keeps its promise to those who have sacrificed physically and mentally for this country. Veterans' disability is the promise made into law that the United States government will give benefits to the veterans of the United States military who were injured physically or mentally during or because of their military service. The United States government developed the Department of Veterans Affairs, which we often call the VA, to administer these benefits. Veterans who believe they're eligible for these benefits submit claims to the VA for various benefits. The VA decides these claims and handles the appeals in these claims. They even have what are called veterans law judges, sometimes referred to as VLJs, who hold hearings and issue decisions. Like I said before, it's a slow, time-consuming, and tedious process to adjudicate claims before the VA. This is why lawyers are so essential to facilitate the process fairly to veterans who are deserving of these benefits. This is, like I said, it follows the text we call the Practitioner's Edition of Introduction to Veterans Disability Law. This edition will focus primarily on topics that a private practitioner will need to know to effectively practice veterans disability law. This edition assumes that the practitioner is accredited or working under an accredited lawyer. Though there are non-attorneys allowed to practice before the VA, this edition is geared primarily for attorneys and staff who practice, though non-attorney practitioners may also find some value in the topics. We do include some sections geared more for the non-attorney practitioners as well. Now, like all types of law, much of this is about presentation. It's a show. Persuasion is best practiced through great presentation. Just like the silver screen prefers big-budget films, the VA is better persuaded by thorough and well-developed case presentation. This does not necessarily mean that the practitioner needs to spend significant amounts of money. In fact, the practice of veterans disability law is relatively inexpensive compared to many other contingency fee practices. Yet, spending money can still be very helpful. An attorney practitioner should be designing the case with the final presentation to a VLJ in mind at all times. Everything builds up to this presentation to a VLJ. If presented well, the case will prevail. In the event that it does not end well, a strong presentation to a VLJ will still make it more likely that the attorney will prevail on appeal. Remember that at all times, everything is submitted in terms of building a story. It will be read by many, including judges. If the special effects of a movie look poor, the movie will generally not do well. Likewise, if the presentation of a veteran's disability case is poor, the VA will generally not be persuaded in granting disability benefits. Keep presentation in mind throughout all aspects of the case. Just like litigators will say that every case should be prepared as if it's going to trial, every veteran's disability case should be prepared as if it is going to a final hearing before a veterans law judge. In fact, while very few civil cases actually go to trial, many veterans' disability cases are finally resolved by a decision by a veterans law judge. Remember, it all builds to the final presentation. So what is it? What is veterans disability law? Well, it's called many things. Sometimes it may be called VA disability law, VA law, veterans law, or even military law. It's a relatively unknown field. It's likely different than anything else an attorney has practiced or studied. It's mostly agency law, so some things are similar, especially to Social Security disability, yet most aspects of VA law are very unique to any other field. Ultimately, in a veteran's disability case, the veteran will be seeking the highest evaluation, also called a rating. The VA rates disability in percentages, and it uses increments of 10. So those percentages range from 0 to 100, and again in increments of 10. So 0, 10, 20, 30, 40, 50, 60, 70, 80, 90, and 100%. The worse the VA finds the severity, or the more severe the VA finds the disability, another way of putting it, the higher the rating the VA will grant. The higher the rating, the more money the veteran will receive. So the more severe, the higher the rating, the more money. And that money is paid every month. Hence, the veteran is usually attempting to seek the combined rating of disability that is the highest and will give him or her the most money. To do this, the veteran must first prove that the disability is caused by or attributable to the military service. This is what's called proving service connection. They have to prove that the disability is service connected. Only once service connection is established does the VA rate the disability. Accordingly, depending on when the veteran becomes a client, the practitioners may have to prove both service connection and that the veteran deserves a specific rating. Veterans may seek representation at any time during the claims process. Sometimes the veterans will seek representation even before filing a claim. More often, veterans will seek representation after they have filed a claim and been denied service connection for one or more disabilities. Also, frequently, veterans will seek representation after they have been granted service connection, but given a rating that is unjustifiably low. Depending on when the veterans seek representation, the practitioner may have to do more or less work. Overall, most practitioners will be proving two overarching things in their cases: service connection and a specific rating or evaluation. While this theme is essentially the same along all cases, it will quickly become apparent that there is still a wide variety in each case depending on the client, the facts, and the disability. Perhaps the most foreign aspect to practitioners is the process of these claims. It's bizarre to say the least. It's especially difficult because each disability is treated as a separate claim, which means the case may have various claims at various steps of the process. To add confusion, there's an older process called the legacy process and a newer process called the Appeals Modernization Act, often referred to as AMA for short. Sometimes the case will involve both processes on various claims. So you might have a claim for knee that's a legacy claim up before a VLJ. You might have a claim for an elbow, let's say, that's an AMA claim that's in a higher level review. And these claims are going on at the same time, but they're different processes. They're being decided differently. The rules of evidence are different. It's very confusing. So we're going to spend some time on the process as we progress in our understanding. Because of that, understanding the process will become essential to truly understanding how to effectively represent a client in veterans' disability case. Accordingly, an entire section, like I said, will be devoted to this. However, in this overview, it's important only to understand the process at a very general level. So take a look in the materials at this very simple process chart. You see the two charts, the Legacy Appeals process and the Appeals Modernization Act. So we see under the Legacy Appeals process that a claim is filed on what's called a VA Form 21-526EZ. Once that's done, a decision is made. That's called a rating decision. After that, a Notice of Disagreement is filed. It has to be filed in 1 year or less, and Once that's filed, the VA has to issue what's called a statement of the case, oftentimes referred to as SOC. Within 60 days of that, the veteran must file what's called a substantive appeal on a VA Form 9. After that, at some point, the issues are certified to the Board of Veterans' Appeals, it's docketed by the Board of Veterans' Appeals, and then it's decided by the Board of Veterans' Appeals. Now, the Board of Veterans' Appeals, where the VLJs are, the Veterans Law Judges. So after it's docketed, it will be decided by a VLJ and sometimes have a hearing. So the next steps from there would involve an appeal to the court system, which is a process that, well, frankly, it's bizarre of itself. For the purposes of this overview, and because most practitioners do not practice as much before the court as they do before the VA agency itself, discussion of the court process will be reserved for a future discussion. Now, the Appeals Modernization Act is even more confusing. At least the legacy process is relatively linear. The Appeals Modernization Act, it's almost a choose-your-own-adventure book in some ways. You file a new claim on a VA Form 21-526EZ, so that's very similar. And then a decision is made. Again, it's a rating decision. From here, you have 1 year to file the next appellate-type document. So far, it's been pretty much the same. In the legacy, you file the 526EZ or 21-526EZ. Sometimes we abbreviate it 526EZ for short. A decision's made, that's the same. Then you have 1 year to appeal, same as the Appeals Modernization Act. Under the Appeals Modernization Act, this is where it gets tricky. You have 3 different options after the decision is made. You can file what's called a supplemental claim on a VA Form 20-0995. This is like filing a new claim, but if you do it within a year and you file it with new and relevant evidence, you get the same effective date. Alternatively, you could request a higher level review. You do that on a Form 20-0996. This goes up to a more senior level reviewer, still not usually an attorney or a judge. You can request an informal teleconference, but it's not required. The third option is to file what's called a Notice of Disagreement. This is done on a VA Form 10182. It's a different form than the previous Notice of Disagreement. That will take it up to the Board of Veterans' Appeals. And there you get 3 different options. That'll be discussed later. For now, you just kind of need to know the process generally. The strange thing about this is that even once you get a higher level review decision or a decision on a supplemental claim, or even a Board of Veterans' Appeals decision, you can file a supplemental claim on that within 1 year without losing the effective date. So it's a very cyclical process. It's very confusing. It's very much a choose-your-own-adventure type appeals process, in my opinion. Again, you can appeal board decisions, Board of Veterans' Appeals decisions, that is, to the court. That's beyond the scope of this introduction. So we've talked a little bit about VA law being agency law. And typically people think of lawyers as practicing before courts. Yet, when lawyers are practicing before the VA, they're actually practicing before an agency. This is done under Article 1 of the Constitution versus Article 3 of the Constitution. In some ways, it may be considered a distinction without a difference for practitioners, as they still must follow rules, follow the law, and prove their case, oftentimes to judges. The biggest difference is likely the fact that these judges are technically administrative law judges, sometimes referred to as ALJs, which means their powers are generally more limited than that of an Article 3 regular court judge. It also means that there are generally no rules of evidence, which means that anything that is relevant is admissible. In the case of the VA, it's also considered a non-adversarial process, which means there's no opposing lawyer. Unfortunately, since a non-adversarial process, the professional ethical rules, Unfortunately, since it's a non-adversarial process, the professional ethical rules for most, if not all, lawyers require that the lawyer disclose any material fact to the case, even if negative to the client. We'll talk more about this a little bit later in this section. The agency practice means that the presentation of the case is very important. Nothing is strictly inadmissible, even if it's hearsay. It also means the practitioner must be careful not to obtain evidence that is not supportive of the case, because even that evidence must generally be submitted unless it's protected by certain privilege. The other important thing to consider about agency practice is that changes the way you research law. Though most are done by federal statutes, a lot of the law is actually found in Title 38 of the Code of Federal Regulations. Accordingly, this is generally the starting point to look, though there are still cases on point. Nevertheless, as a creature of code, such as agency law is, the code itself is generally the starting point. So start with Title 38 of the Code of Federal Regulations anytime you're researching. Now, one of the things we've talked a little bit about is after proving service connection, you get rated, and they compensate these rates based again on the severity of the rating. So one of the biggest benefits in VA disability for your clients is the compensation, the monetary compensation. And again, depending on what it is, it varies. Generally, it's based on what's called a combined rating. So each disability gets a separate rating. A knee might get a 10% rating, an elbow might get a 10% rating, psychiatric rating might get a 70% rating, and then they do what we in the practice call VA math. They don't add it all together, they take percentages of percentages. And based on that, you get the combined rating of something between 0 and 100% in increments of 10. Then the payment is based on a prescription that's set by the VA. And the VA compensation rates for each rating change each year based on the cost of living adjustment, called COLA, or sometimes called COLA. To find the most accurate compensation amounts, it's best to visit the VA's website on this. It's updated yearly based on those cost of living adjustments. And that can be found in your material, but it's www.va.gov/disability/compensation-rates/veteran-rates. Additionally, the rates also increase depending on the family size, provided that, of course, that the veteran receive a rating of 30% or higher. Below 30%, they don't care about the family size. 30% or more, they do take into account the family size. Family members are called dependents, and this includes minor children and spouses generally. In some situations, it can include other categories of family members. Veterans who only receive 10% or 20%, like I said, receive the same compensation regardless of the size of their families. Veterans who receive a 0% rating don't receive any compensation, but are still considered service-connected for those disabilities. To make matters even more confusing, like I said earlier, each disability is rated separately. Then the disabilities are combined into an overall rating. Again, they do this through what we like to call VA math, because they just don't add the ratings together. They take a percentage of a percentage. The easiest way to figure this out is to go to the combined ratings table that's put up by the VA. That's in I can't even really say the URL for this because it's got different kinds of characters that are not letters. So look at the materials, the link is in there. Let's see. Due to the complicated mathematics of this, it's a very nuanced topic, and you'll have to know more about this later if you get into it in depth. But for now, in an introductory course, I think that's all we really need to cover. Next thing we should cover in the introductory course is how practitioners get paid. Payment to the practitioners is almost as complicated as everything else in veterans disability. It's again governed by the Code of Federal Regulations. Specifically, it's governed by 38 CFR Section 14636. In order to legally receive payment for services in connection with representation, the person providing services must be an accredited agent or attorney. Only accredited agents and attorneys are legally permitted to receive any attorney's fees or agency fees. Additionally, every accredited agent and attorney must have a fee agreement for payment of fees. This fee agreement must be signed by the accredited agent or accredited attorney and the claimant that is being represented by that accredited agent or accredited attorney. The fee agreement must include the name of the veteran, the name of the claimant or appellant if it's different than the veteran, the applicable VA file number, and the terms of the payment. If a disinterested third party will pay, then that third party must also be named in the fee agreement. The fee agreement may designate the following terms of payment: fixed fee, hourly rate, percentage of benefits recovered, which we oftentimes call a contingency fee, or a combination of those. Most practitioners, including this practice, tend to use a contingency fee basis. So that's the percentage of benefits recovered, as they term it under the statute. Under any basis, the fees must be reasonable and may only be charged after a specific event in these cases has occurred. In AMA claims, I'm going with this first, even though the legacy claims process still does exist and you still may see it, most new claims filed and most of the claims you're going to see are under the AMA. In AMA claims, the fee can only be charged after an agency of original jurisdiction has issued a notice of initial decision on a claim or claims, or an initial decision on a supplemental decision that was filed more than 1 year after the final decision. So that's pretty complicated, but basically it means that the agency had to get one free bite at the apple. It had to be able to make a decision before you can claim anything. If you help a veteran file and he gets an award, you have never filed an appeal, you never filed a supplemental claim, you don't get any fees for that. Only if you file a supplemental claim within a year or an appeal filed timely do you get a percentage of the back pay, or any fees if you're using other methods. Let's see. So, trying to say, I lost my place here. What that means is that a lot of practitioners won't help claimants file new claims because if they do, they know they'll be likely working on a pro bono basis. Some practitioners, including myself, will engage in representation filing these claims because they know the VA is going to get it wrong a lot. Others may engage in a limited representation basis until they get a denial or they get a claim that's underrated, and then they jump in. Additionally, it's important for practitioners to remember that the fees must be reasonable. A fee is presumptively reasonable if it's less than or equal to 20% of past due benefits awarded. A fee is presumptively unreasonable if it's more than 33 1/3% of benefits awarded. However, this can be rebutted. For fees less than or equal to 20% of past due benefits awarded, the VA may withhold that amount for the claimant's award and pay the practitioner directly, provided that all requirements are met in accordance with law and the fee agreement specifically states that such benefits will be withheld and paid directly to the practitioner. For all other arrangements, the benefits will be paid directly to the claimant and the practitioner will have to collect from the claimant. So some practitioners, they like to do the 20% because that means the VA withholds it and pays them directly. Our practice, we tend to do a higher rate, 33 1/3%. Now, this is a little bit more risky because the benefits are paid to the claimant rather than to us, and we have to collect from the claimant. However, it allows us to do what I believe is a better job because we can take fewer cases, have more interaction with the client, and it ensures that we build a better relationship with the client. Let's see, there's one more major thing that a practitioner must do to legally collect fees. For direct payment, or called withholding sometimes, the fee agreements must be filed to the agency of original jurisdiction within 30 days of the execution of that fee agreement. For non-withholding fee agreements, that's those that are not eligible for direct pay, like the 33 1/3%, the practitioner must submit that fee agreement to the Office of General Counsel within 30 days of execution. So to collect a fee, you have to enter into a fee agreement. It has to state what kind of terms there are, has to state the VA file number, the veteran's name, the claimant's name if different, the attorney, and has to be filed with the proper authority within 30 days of execution. Yes, it's a complex process. Luckily, it's more complex than it is complicated. While this is likely more than you wanted to know in an introductory chapter, this section contains more detail than the others because legal collections of fees is how you keep running your practice. Whomever is responsible for creating these fee agreements must be very familiar with 38 CFR 14636. Again, that's 38 CFR section 14636. Look it up, read it. If you're a support staff, you may not need to know it as well. If you're a practitioner, you definitely need to read this one and understand it. Basically, the takeaway as it pertains to fee agreements is this, and I've broken it down into a 5-step chart in the materials. The fee agreement must be signed in writing and signed by all parties. The fee agreement must designate the terms of pay. The fee agreement must be sent to the proper authority within 30 days of execution. Remember, for direct pay, that's sent directly to the AOJ, the Agency of Original Jurisdiction. For non-withholding, that's sent to the Office of General Counsel. Next, the fees must be reasonable. And finally, you cannot collect on new claims. Now, to file a fee petition, like I said, or a fee agreement rather, you have to mail it to the correct authority. If you're sending it to the AOJ, you can mail it or fax it. You do that to the Department of Veterans Affairs Claims Intake Center, P.O. Box 4444, Janesville, Wisconsin 53547, or fax it to 844-531-7818. To file a fee agreement with the Office of General Counsel, mail it to this address: Office of the General Counsel, parentheses 022D, end parentheses, Department of Veterans Affairs, 810 Vermont Avenue, NW, Washington, D.C. 20420. All right, the next question is, who is a practitioner and how do you become a practitioner? To practice before the VA, any practitioner must be an accredited representative. That's true even for licensed attorneys. This process and requirements thereof are best articulated under 38 CFR Section 14.629. Again, that's 38 CFR 14.629. If you're trying to get accredited, you need to read this. The accreditation process, luckily, is longer than it is difficult. A practitioner must complete a VA Form 21A. The form must be submitted to the Office of General Counsel. Then, the Office of General Counsel will approve or deny accreditation. That form, along with many other reading materials on this topic, can be found on the VA's accreditation website, which is www.va.gov/OGC/accreditation.asp. That website can also be found in the materials. Additionally, a non-attorney practitioner will have to complete an examination to receive accreditation. Attorneys practitioners, luckily, are exempt from this examination. Then, within 12 months, the practitioner must complete 3 Veterans Law CLEs. Thereafter, every other year, the practitioner must complete 3 Veterans Law CLEs. So it's not that hard. They understand that there's not a lot of people who do this, and so they allow you to learn as you go. You don't have to prove competency before you're accredited necessarily. Additionally, every year after you're accredited, you must submit information about any court, bar, or federal or state agency to which you're admitted and authorized to appear. If there's any change to that, you have to notify them within 30 days of any such change. Then, once you're accredited, you can represent a client before the VA, but with each client, you have to file what's called a VA Form 21-22A. It's called a power of attorney by the VA. It basically is your notice of appearance for attorneys. That's essentially what it is. It's an appointment of representation. It's VA Form 21-22A. You have to do it for every client you represent, just like you'd file a notice of appearance. Additionally, a legal intern, law student, or paralegal cannot be independently accredited, but is permitted to assist in a VA case under the direct supervision of an accredited attorney of record. Such assistance, if specifically consented to by the client in writing and furnished to the VA in the proper manner, may include such actions as representation at any hearing, providing that the supervising attorney is present. This is governed under 38 CFR Section 14.629, subsection 3. Additionally, if the claimant consents in writing, an attorney associated with the claimant's attorney of record may also assist in the presentation. This is under 38 CFR Section 14.629, subsection 4. So that's how you become a practitioner. Let's talk a little bit about the overview of ethical duties. Now, in the practice of law, attorneys are bound by ethical rules. If the practitioner is an attorney, the attorney is bound by the ethical rules of which that attorney is licensed and by the Code of Federal Regulations. If the practitioner is a non-attorney, that practitioner is only bound by the Code of Federal Regulations. It's important to note the distinction of non-attorney staff versus non-attorney practitioners. Most attorneys will employ support staff. The attorney must supervise that support staff, and that support staff must comply with all ethical rules under which that attorney is bound. Non-attorney staff are not non-attorney practitioners. A non-attorney practitioner, or accredited agent as it's officially called by the VA, is a person who is authorized to represent veterans before the VA even though that person does not have a license to practice law. So if you're support staff, you are not a non-attorney practitioner. You are non-attorney staff. There's a big difference. You can't do the same things that non-attorney practitioners can do. Now, whether you're an attorney or non-attorney practitioner, it's very important to know in detail the ethical rules that govern your practice. This introductory is not sufficient for an attorney or a practitioner to understand all of these rules and duties. It does only provide an introduction, which means you're going to have to look it up. You're going to have to know it. Support staff, defer to your attorneys on this. They should know it. You should know it to some extent, but you certainly don't have to know it as well as the attorneys. If you have any questions about it, ask your attorney. Some big issues that arise in representing veterans are the same as in most areas of representation. The attorney or non-attorney practitioner must faithfully provide representation to his client, his or her client. The attorney or non-attorney practitioner must be competent to represent that client. The attorney or non-attorney practitioner must communicate with that client. Pretty simple, pretty straightforward. You're going to have that in all areas. One big issue that's oftentimes the topic of debate is whether the attorney or non-attorney practitioner must disclose all evidence to the VA. We take the position that the attorney must certainly disclose everything that's material to the claim to the VA, whether it's helpful or harmful to the claim, the only exception being if it is protected by some legal privilege. Most state ethical rules, including Florida, where I'm licensed, and the model rules of the ABA, the American Bar Association, state exactly that for representation in all non-adversarial tribunals. That is that you must disclose all material facts. And that means you have to disclose even harmful things when you're representing a client in a non-adversarial tribunal. The VA, again, is agency law that is non-adversarial. So you do have to disclose everything according to the model rules. Therefore, attorneys must disclose even harmful documents to the VA. Now, an attorney might try to mitigate it by providing counter evidence or providing argument as to why the harmful document should not be considered. Therefore, if any support staff discovers a document that's not submitted, even if it hurts the case, they should let the attorney know immediately. The attorney may have to disclose it, but may be able to mitigate it. The attorney may also decide, in accordance with his or her duty to communicate with the client, that the document must be submitted, but may hurt the case. They may have to communicate with that with the client, and if the client says not to submit it, the attorney may need to withdraw representation. The issue of submission is less clear from the non-attorney practitioner. Some texts take the position that there's no duty to submit harmful evidence. However, 38 CFR section 14-632 subsection A2 states that, quote, all individuals providing representation are required to be truthful in their dealings with the claimants and the VA. Moreover, 38 CFR Section 14-632, subsection B2, states that a person representing the claimant must act with reasonable diligence and respond promptly to VA requests for information or assisting a claimant in responding promptly to VA requests for information. Subsection A2 of this alone arguably requires that the non-attorney practitioner disclose all evidence because they must deal truthfully with the VA. When read in conjunction with subsection B2, depending on the extent of the request by the VA, it certainly may require disclosure of evidence, even if unfavorable. While this text, and I generally take the position to encourage zealous advocacy and zealous representation of your clients, Compliance with ethical rules should be done stringently and in a conservative fashion. That is not the time to take risks. That is not the time to try new things. You do not want to lose your license. No single case is worth your license. So do it very conservatively. If you have questions, consult with your attorney friends. Consult with the other practitioners. Get those questions answered. The OGC can sometimes answer some questions for you, the Office of General Counsel, that is. So if you have any questions, don't just act on it immediately. You want to be careful and calculated when dealing with ethics. There you have it. That's a brief introduction to veterans disability law. If you haven't had any experience or your support staff, this might be the most important and most informative topic that we're going to cover. The rest are a little bit more nuanced, or a little bit more in depth. It's certainly good to know it, but from just a very broad perspective, that is an overview of VA. It's pretty complicated. That's why we recorded this. Listen to it multiple times if you have to. Read and reread the materials multiple times until you get this. It's complicated. I'm going to continue to try to update these. I just needed to get something out now, something you could listen to, something you could read, something to get started on training. In the future, I hope to do videos. I'm going to do a little bit more kind of quizzes so you've got more interaction with this, and I'm going to try to provide some supplemental materials. For now, this is a work in progress, so I apologize it's a bit choppy, but hopefully it was pretty informative. If you have any questions, read it, reread it, listen to it again. If I have the quiz up, do the practice materials. It'll be helpful to interact with it a little bit. And the next chapter is probably going to be even harder. While we covered a lot of material in this, the next chapter is going more in depth in the process of these VA claims. That's that AMA and legacy appeal. And so it's confusing to say the least. Practitioners who have been doing it for a while still get confused. The VA gets confused. We've had to file several petitions to the court to get them to act the way that they're supposed to. It's hard stuff, but make sure you study it, because if you know the process, you can do anything else in this. So thanks for listening, and I'll talk to you later.